Jai Hind, welcome to GS NEXUS Current Affairs series. Recently, Centre opposes plea in Supreme Court to impose lifetime ban on convicted politician. So in this regard, we will discuss about the news. Let's first know why in news. The Union government had filed a counter affidavit in the Supreme Court opposing a plea to ban politicians permanently from contesting election upon their conviction in criminal cases. The government said that the period of disqualification is a matter which is purely within the domain of legislative policy. The petitioner has challenged Section 8 and 9 of the Representation of People Act 1951. Now let's know why it becomes matter of concern. As many as 251, that is 46% of the 543 elected Lok Sabha members in 2024 election had criminal cases registered against them, and 27 of them have been convicted, according to an analysis by Election Watchdog Association of Democratic Reform, that is ADR. This is the highest number of candidates facing criminal charges to be elected to the lower house. Now let's know the background of disqualification. First, under Section 8 Clause 1 of the Representation of People Act 1951, the period of disqualification is 6 years from the date of conviction, or in case of imprisonment, 6 years from the date of release. Second is, under Section 9 of the Representation of People Act, public servants who have been dismissed for the corruption or for disloyalty to the state shall be disqualified for a period of 5 years from the date of such dismissal. Third is, Article 102 and 191 of the Constitution deals with the disqualifications for the member of either House of Parliament, Legislative Assembly or Legislative Council. Fourth is, the Centre said Clause E of Article 102 and 191 were enabling provisions that confer on Parliament the power to make laws governing disqualification, and it was in exercise of this power that 1951 Act was enacted. The grounds of disqualification in the article include holding of an office of profit, unsoundness of mind, insolvency, and not being a citizen of India. And fifth is, the Constitution has left the field open to Parliament to enact such further law governing disqualification as it deems fit. Parliament has power both to determine the ground of disqualification and the duration of disqualification. Now let's see government argument. The government said whether a lifetime ban would be appropriate or not was a question that was solely within the domain of Parliament. The government also emphasized that the numerous penal laws impose time-bound restrictions on disqualification. There is nothing inherently unconstitutional about limiting the impact of penalties to a specific period. That's all for today. For more such videos, stay tuned with GS NEXUS.